Justices Jackson and Sotomayor were caught gaslighting the rest of the Supreme Court on prepositions. You cannot make this stuff up. So to understand what's going on, let's take a look at the law itself. According to 8 U.S. Code Section 1158, any alien who is physically present in the United States or who arrives in the United States, irrespective of such alien status, may apply for asylum in accordance with this section or, where applicable, Section 1125B of this title. So this case at the Supreme Court, because of Justices Jackson and Sotomayor, really devolved into this argument over prepositions. What does it mean to be in the United States? They started using this analogy of going to your friend's house. If you knock on the door of the house, are you arriving at the house? Are you arriving in the house? Are you in the house, at the house? It was just absolutely bonkers, especially since I think most middle schoolers would be able to parse apart these prepositions, would be able to figure out exactly the difference between these two letters, these two words. Yet we have grown adults who are arguing amongst themselves over this. So the reason this matters is because the United States has an extremely gracious asylum policy. You saw it there. If you are a refugee, if you are being persecuted, you can come to the United States. Your immigration doesn't matter. As long as you are here in the States, you can seek asylum. Now, of course, that doesn't mean that your claim is going to be granted or approved, but you at least have that right. You have that privilege. However, that is not without its downsides. Obviously, people can take advantage of that. You still have to vet the people coming in. And in fact, it turned into such a crisis that it was a Democrat president. Yeah, it wasn't a Republican. It wasn't President Trump. It was a Democrat who introduced this concept of metering. Just take a look at this article from NPR. Obama administration ends refugee policy that favored Cubans. So this policy began under Bill Clinton, and there are two components to it. There's the wet foot policy and the dry foot policy. The wet foot policy refers to if you're on a boat, right? Let's say you're on a boat coming to the U.S. and you're seeking asylum. Well, because you're on a boat, you are on international waters, which means you are not in the United States. So if the U.S. intercepted your boat, they could turn you around. They wouldn't necessarily send you back to your home country, but they'd say, you can't come any further, you have to go somewhere else. But the dry foot policy was different. Again, the law says your immigration status doesn't matter. So the dry foot was as long as you were in the United States on dry land, then you can seek asylum. However, it was Barack Obama who wanted to end the dry foot policy. Why? Because he said people are taking advantage of this. You need to show your documentation. Again, this is President Barack Obama, not President Trump. This is his statement, his words. Effective immediately, Cuban nationals who attempt to enter the United States illegally and do not qualify for humanitarian relief will be subject to removal consistent with U.S. law enforcement priorities. Okay, so to summarize all of this, Barack Obama began this, President Trump continued it, and then President Joe Biden rescinded this. He put an end to that period. While the Trump administration is arguing, we don't want to do this 24/7, we don't want to necessarily put these policies back in place, but we want to have an option just in case things get crazy and busy again. That's what they're arguing at the Supreme Court, but instead, Justices Jackson and Sotomayor, well, they are arguing over prepositions, and Justice Jackson actually attempted to switch the framing of the entire argument. Take a look at this.
I don't understand how that's responsive to my point, which is the person who is arriving in the United States asking for permission to enter is not necessarily, quote, in Mexico in a way that implicates all the concerns that you're talking about. Yes, he is physically standing in Mexico, but imagine a person who has a placard on their body as they approach the border that says, you know, I would like entry, I'm being persecuted in Mexico. Your suggestion that the United States would say, unless you can figure out a way to illegally cross, we're not going to entertain that claim, seems very peculiar.
It seems to me that the premise of the question is that there is something improper about blocking someone from completing the arrival.
The premise of the question is that arriving in has to mean something. Yes. And to suggest that it means that you have to actually illegally cross doesn't make sense.
There are other penalties that apply to people who illegally cross. It's a crime to illegally cross into the United States. And the fact that someone has illegally crossed into the United States can be taken into account when the person is making the asylum application.
Sorry, please. Counsel, the statutory language, is it arriving in or is it arrives in?
It arrives in.
Okay.
Yeah, so not only do they spend an entire hour arguing over prepositions, but they also argue over which tense of arrive to use. What's really interesting, though, is Jackson's assumptions she makes in her arguments, because according to her, apparently you can't arrive in the United States without coming here illegally. That's basically what she's saying. That's why she's arguing. You're saying that they have to break the law? You're saying that they have to come here illegally? No one is saying that, Justice Jackson. You're the one assuming that. You're the one bringing Democrat politics into the courtroom, which I thought was supposed to be apolitical. On top of that, they start arguing over whether or not it's morally right, morally wrong for the U.S. or for any government to stop people before they actually get to their border. But again, don't forget, this began way before President Trump. Barack Obama was doing this. This has been going on for years. And in fact, they actually cited this instance in 1939 when a boat was turned away. And Justice Sotomayor, instead of focusing on the arguments of the case, she actually tried to appeal to everyone's emotions here. Just take a close listen to what she said.
No, because the SAIL made very clear that the UN obligation is, if you're a refugee who's arriving at the port of entry, if you're knocking on the door and I'm staring you in the face, you have an obligation to at least listen to my application. And you can tell me to wait, you can put me in a safer place to wait, you can do a bunch of different things. What you can't do is just turn me back from the border.
And the second answer is we're not shipping people back to Haiti or whichever country the person might be coming from.
No, you're just telling them walk back.
No, we're not
so
telling them anything.
The people on the St. Louis could have swam back. They happened to be on a boat. But that's what we did. They were off the coast of Florida, and we didn't let them dock. We didn't let them dock and take and interview them at all. We didn't consider whether they were being persecuted. And the majority of those people were shipped back or had to go back from where they came and were killed. That's what we're doing here, isn't it?
Like the court in SAIL, I do not deny the moral weight of claims made by refugees, but that is not the question before the court. The question before the court.
I mean, obviously, that is a tragic story in history, but it's not the job of the Supreme Court to make decisions based off of emotions. It's not even their job to rule based on what they think is morally right or morally wrong. It is their job to interpret the law as it is written. And guess what? If you don't like the law, that's why Congress exists. Congress writes the law. Guess what? They can change the law. We can even change the Constitution. Our forefathers were very prescient about all of these considerations. But that's not what Justice Sotomayor is focusing on here. She's clearly trying to appeal to everyone's emotions in the room, and you'll notice what she did. She actually used the phrase arrives at. She changed the preposition. Instead of arriving in, arrives in, it's arrives at. Well, her and Justice Jackson, they were doing this the entire time, and guess what? Justice Alito had enough. It was very obvious what they were doing. They were attempting to change the language in real time. They were confusing and distracting everyone from the issues at hand, so Justice Alito called them out.
Can you speak a little?
It'll be interesting to read the actual transcript of the oral argument, because I believe that both you and Justice Sotomayor and Justice Jackson on several occasions have used the phrase arriving at. I think you said you arrived at your house, but that's not the term that is in the statute. Do you think there is no difference between arriving at a location and arriving in the location?
Yes, thank you for the opportunity to clarify. So we have in the United States at a port of entry. I can explain the amendment history on how we ended up with the prepositional phrases in that order. But I think that my first order answer is in is just how you describe being in a region. You wouldn't say at the United States. You would say in the United States. I am arriving in Baltimore when I'm on the train as it's coming in. I am at Penn Station when I'm in New York. So that's the difference in prepositional phrases, which even if it doesn't completely answer the question, does give you some pause to say, well, maybe in isn't doing the work that the government is suggesting here because it has to do with kind of the natural way that we talk. But the way we ended up with that order of the prepositional phrases is that
Well, I'm not quite sure I understand that. So there's been talk about knocking at the door. Do you think someone who comes to the front door of a house and knocks at the door has arrived in the house? The person may have arrived at the house.
No, but that's past tense. Are they arriving in the house?
Does a person arrive in the house when the person is not in the house and is knocking at the door, asking to be admitted to the house?
Yes, I think here the door is open. The officer is standing on the other side of the threshold. The person gets there and is ready to take the step over, right? The officers and the asylum seekers here were toe-to-toe. This was happening right at the line, and they're about to step over. They are arriving present tense. Once they're inside, they've arrived past tense, but we know that Congress used the present tense here.
Yeah, and Congress tends to be very specific with its words for a reason. Despite all this arguing over prepositions, let's not lose track of the actual arguments before the Supreme Court. The argument is whether or not the government has a right to stop people before they even reach the border. That's why Justices Jackson and Sotomayor were talking about, is it arriving in, arriving at, because they were trying to expand the reach through which asylum seekers can come in. The reason this is even an issue is because the asylum system right now is broken. There are just so many issues, whether it's not enough staffing, too many people abusing the system. But part of the reason why administrations, both Republican and Democrat, want to turn people away before they even arrive in the United States is because the backlog is so large. Just take a look at this. The Executive Office for Immigration Review Adjudication Statistics. Over 4 million asylum applications are in the backlog right now. Last year, 2025, almost 2.5 million were filed, but they're still pending review. And it keeps building year after year after year. Right now, we still have 4 million to go through. And so that's why administrations turn people away before they even get to the border if they're not coming with the proper documentation, because the manpower, the capacity just isn't there. It's not out of cruelty. It's not because Orange Man bad and he wants human suffering. It's because quite literally a backlog of 4 million, and it's been growing year after year after year. They're trying to find some other solution because Congress isn't taking action. Well, because Justice Jackson doesn't agree with this policy, during the oral arguments, she actually attempted to get this case tossed. Yeah, she wanted to remove the case from the docket in real time. But before we get to that, I would like to acknowledge the members of today's Governor's Club. They are Siwa-chan, Cindy Morgan, Joni, Jeremy 2001 Happy, and Moon Fairy 11. So Justice Jackson started throwing out these clues and these hints to see if any of her fellow justices would pick up on it. No one took the bite. And fortunately, the Solicitor General, Vivek Suri, actually called her out on this, and he made the case why this case should be discussed and argued before the Supreme Court. And they continued with their arguments as if Justice Jackson didn't say anything at all. Take a look at this.
Justice Jackson?
We don't have the answers to Justice Kavanaugh's good questions because there is no policy in effect, right? We don't know.
That is right. I was going to make that point as well, right? Right now we have a legal question that's unanchored from any actual practice before the court.
Thank you.
Yeah.
Thank you, counsel. Rebuttal, Mr. Suri?
Just a few quick points, Mr. Chief Justice. First, this court should decide this case. The case is not moot because there is still effectual relief that the court could award, namely lifting the class-wide declaration and the individual injunction to which the government is still subject. There's also a strong practical reason for the court to decide this case. It's not something the court should leave to future uncertainty. We've been faulted here for not having a specific policy in place, but that's not really fair to us. There's a class-wide declaratory judgment saying that this practice is unlawful, and I think the government should not be faulted for conforming its current conduct to what a court has declared to be the law. Once that declaratory judgment is lifted, we'll take appropriate steps at that time. Second, the text of the statute should control the court's decision, and that text is arrives in the United States. We've heard attempts to substitute other language that might be more ambiguous or more susceptible to respondents' interpretation than the language Congress actually used. For example, we've heard many references to arriving in the United States, but the specific language at issue here is arrives, not arriving.
I thought he made a great point, and what really stood out to me was when he said that the administration doesn't have this policy in place. There is nothing that they're implementing right now, and the reason that's important is because this claim, this media narrative, this Democrat narrative that President Trump, oh, he hates all immigrants, oh, he hates refugees, that's not true. It's not as if this is a blanket policy going on 24/7, and in fact, there are no plans to actually implement this policy. The reason the administration is arguing it is because they want it as a tool in their toolbox for if another caravan comes up through the southern border, or if there's another swell at the borders and they need to handle it because the asylum system is just flooded and overwhelmed and broken. They want as many tools as they can in their toolbox. I thought that really spoke volumes. As always, though, all of this is just my analysis and commentary. That is what's happening in the world of politics from my point of view, and I would love to hear from you. So they spent so much time arguing over if you knock on the door of a house, or in other words, if you arrive at a port of entry, if you arrive at the border, are you actually in the house? Are you in the country? What do you think about that? If you are knocking at the door, are you in the house, arriving in the house, arriving at the house? How would you describe that actual moment of knocking at the door, arriving at the port of entry? Let me know down in the comments below. Personally, I think the law is pretty straightforward here. I don't know why this is such a controversy, but I guess everything's a controversy these days. If you haven't already, please be sure to leave me a thumbs up. I know it's a simple thing to ask for, but it really does help me reach more viewers like you in the algorithm. Be sure to smash that subscribe button and to check out one of these videos.